Any mention?
Yeah, please, Your Lordship. Lordship, I would like to make a mention for an unlisted matter at the end of the board, Lordship. There is an urgency. It's a land acquisition matter without a payment of the compensation and all. They are about to start the construction.
Where? Today it's starting construction?
Yes, Lordship.
Monday or tomorrow?
Well, let it be tomorrow, Lordship.
Question: construction, land acquisition, we have not paid compensation. This is a question of eviction. Yes. One concession tomorrow. Yes.
May I please, Your Lordship, item number 17 of the hearing list may kindly be adjourned for 2 weeks.
Your father side.
Yes, Your Lordship, for petitioner.
16.
17.
Moqsadul.
Moqsadul, Your Lordship. 2 weeks time may be granted.
Why?
Some difficulties there, Your Lordship.
Is that pay commission?
Yes, Your
This is
Lordship.
that all new PS
Pension. Yes.
extensively are good from us.
What her matters? I'm not willing to argue to adjourn it.
No, this is not keeping well, Mr. Sengupta.
Okay, 2 weeks. Yes.
2 weeks.
Much obliged, Your Lordship.
Wait, please, Your Lordship. I beg to mention item number 20. Your Lordship. Item number 20, if this matter may be
28?
20. If this matter may be taken up after 2 weeks, Your Lordship.
No objection, Your Lordship.
Okay, 2 weeks. Yes.
Much obliged.
Supplementary list.
There are
Item,
enough chairs, no? That's the problem.
supplementary list. Item number 1.
My lord, here the petitioner, my lord, he was supposed to receive arrear of pay and allowance for extended scale, and an amount of rupees 1,48,000 was 48,102 rupees was sanctioned, but due to some mistake, my lord, that amount was supposed to be 1,39,294. Previous sanction amount was 1,48,000, so they need re-sanction. But it's almost a year they have not done the re-sanction, my lord.
Why don't you draw that amount they gave earlier and return the excess amount?
They have not given me that amount. That is the problem.
You have to come by writ petition for that. That's all. And
That is only this much, my lord.
Yes, Your Lordship. I may just be allowed to find out why this has not been re-sanctioned again.
No, you re-sanction it. What is there? Nothing is here.
Nothing, my lord.
If you don't.
Earlier also this man had come to the court in
That was
connection with
different,
some
sir.
other matter, so I don't know if it is connected or what, we are not sure about that.
This is for the extended scale.
Regarding wrong scale of pay apparently.
Let's see, it says so-and-so, Annexure 1 says, I'm trying to convey the time barred sanction of government matter to the payment of amount of rupees so-and-so, 1,48,000 being arrears of advance. Okay, fine. Then what happened? Then pray for re-sanction. This is by the district military officer.
So that was
should
not
be
done.
139. Then now,
They have not re-sanctioned that. That's the grievance, Your Lordship. But what
but
is
this
the
from
reason?
who you are paying for the district military officer also, I suppose,
Yes, Your Lordship.
and for DHS also.
Yes, Your Lordship.
Then even if you've given the non-withdrawal certificate, so what? We'll dispose it off. There's nothing here in this case.
I may just be given 3 days time, Your Lordship. I'll just find out what is the reason. If there's any connection with the previous case.
My lord, that is nothing.
Regarding the scale of pay. So what is the?
This is thereafter, my
Okay,
lord.
but Mr. M. Secondary Counsel Petitioner, you should notice MS T. Angel AAG with so-and-so accept notice, which present accept notice on behalf of all the respondents. This is matter on Tuesday. This is 22nd for instructions.
Oblige me.
Item number 2.
May I please, Your Lordship? My lord, I was the in-charge headmaster of the school. I was removed from the in-charge headmaster, my lord. I am being the
In
senior.
charge, do you have any right to hold in charge?
My lord, I am the senior most
is it
teacher. My lord, actually the case is, my lord, I am the founder teacher of the school. I was appointed in the year 1988, my lord. After the retirement of the headmaster in the year 2021, the respondent number 5, the office of the block mission coordinator, prepared a list of seniority list of teachers of the school, and in that list I am the senior most teacher of the school, my lord. Then the same was forwarded to the office of the respondent number 4, SDSCO, my lord, for considering the appointment of as a temporary, my lord, because since there is no managing committee at that point of time also. Thereafter, respondent number 4, SDSCO, issued a letter, my lord, whereby I was given in charge of the in charge headmaster of the school, my lord. Then I have conducted the parent guardian meeting and I forwarded the same for approval. Then the SDSU has approved the managing committee. In that managing committee, I am the in charge headmaster as the ex officio convener. Thereafter, my lord, the managing committee has passed unanimously adopted a resolution whereby I was promoted to the in charge headmaster, being the senior most teacher of the school. All of a sudden, the respondent number 4 has passed the impugn order on 19 June to 2022, my lord, at annexure 9, my lord. Page 28, my lord. May I read, my lord?
What inquiry was this?
My lord, that inquiry was conducted, my lord. After
inquiry,
my lord, that inquiry, my lord, I have participated, but outcome of the inquiry was never communicated to me. Neither the officer has whispered about anything about the inquiry. And the managing committee resolution number 1, dated 6/1/2023, the SDSU has mentioned in the impugn order, my lord, in that resolution, I was the ex officio convener, my lord, at that point of time when the date, my lord. Without signing the ex officio signature, my lord, the resolution itself is not in operation, my lord.
No, but in charge, what right is in charge? In charge. It's not that you are already headmaster.
The issue has to settle, my lord, because in the impugn order, my lord, may I read, my lord?
Yes.
My lord, pursuant to the recommendation of the school managing committee, white resolution number 1, dated 6/1/2023, and based on the inquiry report recommendation of the block mission coordinator SSA, Shalshala, white so and so, dated 2nd May 2023, Shri Hypothali is hereby removed from the ex officio member convener of Nolbari Janata GA UP school until further order, and Shri Abdul Mojid Ahmed, BA DLED assistant teacher of the school, is hereby provisionally approved to act as in charge headmaster with immediate effect. Subsequently, he is also inducted as the ex officio member convener. My lord, he is the junior most teacher, my lord. My lord, may I kindly, my lord, the annexure, my lord, the seniority list prepared by the respondent number 5, my lord, at page 21, my lord. At page 21, my lord. Number
what
1.
Inquiry was there? What's the inquiry about? No. What is the inquiry about?
My lord, that is not communicated.
You said took part. Inquiry was
my lord,
on what reference of what?
The officer come to a school and that they're asking for the document. Who are the teachers? How many students?
Is it
who have
because of
participated?
any illegality, or because just to find out who the senior teachers?
My lord, that is not. They have not disclosed anything.
No, but the thing you must be knowing. You're in charge headmaster. You were there to
yes,
school.
my lord.
But when he came to the school, he didn't say we're going to come here to conduct inquiry on so and so.
Yes, my
regarding so and so. No,
my lord.
What the questions they ask you?
My lord, they ask for the document. Who are the teachers? What are the list of the teachers? Attendance register. We have submitted the list of the students, or how many students are there in the school. We have submitted accordingly. And after that, they have not communicated anything, my lord. And the managing committee resolution they have mentioned in the impugn order, my lord, is the resolution. I am not part of it, my lord. I was the ex officio convener at that point of time, my lord.
Make out. Yes, what do you have to say,
my lord?
May I please, your lordship, this letter, your lordship, annexure 8, page 26, this resolution of the managing committee.
Yes.
It is never forwarded to this letter was never forwarded to the respondent number 4.
No, it is forwarded.
It is nowhere where it is, address is not there, your lordship, where it was.
No, this is the proceedings, the minutes. Where's the covering letter?
It is not, forwarding letter is not there, your lordship.
My lord, at page 23, my lord, I have forwarded the managing committee resolution.
It is 3rd February.
And yes, my lord, 28th February,
let's see.
reconstitution.
Let's see.
My lord.
Yes. So you submitted to the SDSU.
My lord, for necessary approval.
Then forwarded to so-and-so, forwarded to approval of the SDO, that in grey, There was this service to school was without SMBC and the school is requiring urgent attention from the department.
Yes, my lord.
See, so it was approved.
My lord, yes, my lord. Managing committee was approved, my lord.
6.
My lord, managing committee annexure 6, my lord.
1 second. Yes,
Page
with effect
24, my lord.
So where are you? Your
My
name
lord,
is Hepat Ali.
at number 3, my lord.
Okay, yes.
Ex officio member convener.
Yes, then
Thereafter, what?
Then, my lord, annexure 7, page 27. Again, the respondent number 4 had issued the letter of authority whereby the to operate the account jointly,
who is
my
this
lord.
Nazrul Haq?
He is, my lord, he is the chairperson, my lord, of the newly constituted managing committee, my lord. And thereafter, my lord,
Okay, yes. Then you
the impugn order, my lord.
No, your lordship, annexure 8 is the another resolution.
Not the same resolution, that is the same
Dates
resolution.
apart, different date is showing your
No, same. 3-2, my lord.
3/2/22.
Same resolution, my lord.
So I may be allowed to take instruction, your lordship. This
And
is
my lord, annexure, my lord, 11, the assistant, almost all the assistant teacher except the respondent number 7, they have filed one representation in the form of no objection.
yes, heard
the
Mr.
SDO.
Hassan, then council petition.
My lord, I filed a
Issue notice.
miscase, my lord, kindly. Otherwise, I am still operating as the.
Issue notice returnable in 3 weeks. Stop. MS Esbert Haji is present accept notice on behalf of respondents number 1 to 5. Petition step for issue notice number 6 and 7. Stop.
My lord.
The next part of stated case of the petitioner is that he, being the senior most teacher,
Yes, my lord.
had been by managing committee resolution dated 3rd February 2022
But your lordship, it is written
2022 was designated as ex officio member convener.
Yes, my lord.
Stop. The said reconstitution was approved by the by the respondent number. SESC was one. Number 425th number 2022.
Yes, my lord.
Stop. It appears thereafter that the petitioner was then discharging the duties of in charge headmaster pursuant to what?
My lord,
You discharging in charge headmaster pursuant to what?
pursuant to my lord, resolution, my lord, actually my resolution was not approved in the, as per the order, different 2 orders, my lord.
Where is that?
My lord, first one is my lord, annexure 4, 31st 3.
Where they said you should be the in charge headmaster? Where is that?
My lord, the one is my lord, the seniority list prepared by the respondent number 4, annexure 3, 13 January 2022. My lord, the content of the letter.
Where?
My lord, at
The 3.
page 20, my lord, annexure 3.
Yes, Thomno? Not thereafter, it's before that. Stop. Prior to the resolution dated 3/2/2022, it appears the petitioner white order dated letter dated 13 January 2022 was allowed to discharge the functions of the in charge headmaster, being senior most. So, being the senior most. So, in this, however, has been submitted that without any reason and on a piece of inquiry, the report of which is unknown to the writ petitioner, by impugn order dated
19/6/2023.
where is that? Section 8, Section 9.
Yes.
19/6/2023. He has been removed as from the post of being in charge, and respondent number 7 has been provisionally approved to discharge the duties in charge of master staff. Next parameter, S.K. Hassan submits that the entire action of the respondents being without any basis. He prays that in the interim that some.
May I please, your lordship, just a minute.
Some.
As per the list, this respondent number who is appointed, he is having BA diet, your lordship, and he is just simple
Doesn't
matriculate.
matter. Yes, they should at least justify their actions. Thomno? Then some attraction be given to the writ petitioner. Having heard and considered the submissions of the the counsel with the parties. It is directed that the Governor GA obtain instructions within 2 weeks, right? 2 weeks, return of 2 weeks. List also in the interim, the impending order shall not be given effect to. So, yes.
Item number 3.
It's provided interim till the next date. The impending order shall not be given. Impending or dated authority shall not be given effect to.
My lord, here, my lord, in this appeal, we are challenging the order dated 31/10/2022, passed by the Special Judicial Officer Iskasils, my lord, in LA case number.
First appeal.
Yes, ma'am. In LA case number 2K of 2017. My lord, the brief facts of the case is that, my lord, there was a notification under section 4 for acquisition of land for the for an area of about 9,900 square feet under the integrated slum development program for and thereafter, my lord,
no, what is this application for condonation?
My lord, there is one application, my lord, for condonation of delay, my lord. 195 days, my lord.
Yes, for in this case, FA 17/2023 is an application. Limitation Act not applicable land acquisition matters.
My lord, but I have filed one application, my lord, to be in safe side, my lord.
From?
My lord, 195 days delay is there, as per the from the date of
the Limitation Act applicable in land acquisition matters.
My lord,
how?
In my understanding also, my lord, it is not applicable. However, my lord, if I would have filed without the application, there could be a challenge to that effect, my lord.
Anyway, there is the judgment of this court also. An application condition of delay of around 4 days and preferring the connected first appeal. Issue notice to the respondent. Returnable in 3 weeks. Yes. Next first steps be taken within 3 days by the counsel for the appellant. This is the draft one also.
Main list, item number 1.
Your Lordship, we are praying for 3 weeks' time, Your Lordship,
Why?
if I rejoinder, Your Lordship.
How many times you prayed?
This is the second time, Your Lordship.
What's the matter about?
This is regarding Lordship appointment of a teacher. They took part in the selection process. Appointment of assistant teacher in the school, Your Lordship.
How many?
Your Lordship.
Two of them. One.
In the other matter, Your Lordship, in the first matter, appointment of teacher, there were two posts, and in the second.
So what's the other matter? Is here today?
Your Lordship, it's the second matter, Your Lordship. These are also connected matters.
Yes, MS will talk please for a lot further 3 weeks time for rejoinder. This thereafter and so on. Anything, Mr. Barasaji?
Your Lordship, in the second matter, we've already filed our service affidavit of service, which we've taken.
In item number 2, Lord, I am entering appearance on behalf of respondent number 7, my lord.
Yes, who's?
7.
Who was number 4?
Your Lordship, respondent 4 has not yet filed in this matter. Actually, there's some.
You are represented?
4, I am represented.
Okay. Then number 7, Office Mr. Kivu Rachaji has entered appearance today on behalf of respondent number 7. So service is complete now.
Your Lordship.
Correspondence.
My lord, so far I am entering only for my lord respondent number 7.
No, okay. I'm asking her. Service complete all respondents.
Your Lordship. Yes, Your Lordship. All the respondents.
According as such, not recorded last time. First time you're appearing for 7 and Mr. Espande, correct? For number 5. And you've been?
I am for respondent number 8. My lord, I want to submit something, my lord.
And Mr. Yobin for number 8. First time you're appearing?
No, my lord. I've filed my affidavit already.
Yes, what do you have to submit?
My lord, ever since we have been selected, my lord, we have been working in the school now. It's been like 5-6 months already, my lord. and our salary has not been paid, and there is no stay in these petitions, my lord, and we are having a very big problem.
Up to Mr. Shulai to advise his clients.
The managing, it has to be the managing committee.
By the managing committee.
Who is managing committee? Mr. Hassan?
R5, your lordship, R5.
Mr. Sheikh is a... He's interrupting today.
The managing committee is not preparing the salary on the school. That was supposed to be filed before the state respondent. Then salary will be released. The managing principal and the managing committee. We are continuously serving.
Since I am the principal of the school, so I am also aware of the...
Who is the principal? Mr. Hassan's principal or you are the principal?
I am the principal. He is for the private hospital, other private hospital. Now, Lordship, the appointment was temporary because the appointment was made prior approval from the government. Then subsequently they got the approval. After the approval, no appointment was made to that. That is why the so far as I go.
You file the affidavits.
Technically, they have already given my lord by the director.
We're not going to go to that now. There are no materials here to see whether they appeared or not. Mr. S. Pandey on behalf of 5. Mr. Such service is complete stuff. Who has not filed affidavits?
Respondent for your lordship.
4 is?
The principal, your lordship.
Item number 1 I have filed.
Okay.
Mr. S. A. Sheikh submits that affidavit has been filed in WPC number. That's before that.
In WPC
or 2022. No affidavit be filed in this present matter, in the instant matter. What about the others?
State has filed a long time back, your lordship.
You already filed
the writ petition.
What about Mr. Bhattacharjee?
Because I have entered appearance today, my lord.
Whatever it is, are you filing or not?
Yes.
And Mr. Pandey will be filing. Mr. Pandey for file number 7 and pay for allowed 2 weeks time to file affidavits. This thereafter and so on so.
Oblige, your lordship.
Item number 3.
My lord, I have filed a service report by way of an affidavit. Yesterday only I have filed it.
Yeah, appearing.
Or some have received, yes.
Appearing for respondent number 1, 3 and 6, your lordship.
Like before, yes.
How many responses are there?
6. Earlier also these 3 had appeared, others had not appeared actually.
One, 3 and 6. 1 is Arvis 3, 1, 3 and 6.
Yes, your lordship.
What about number 2 and 4 and 5? 2, 4 and 5. Mr. Bora, 2 and 5 are returned back unserved.
Yes, unserved. Last time also they had not appeared. In the previous case also, they were also the parties there.
As the address expired, he's died.
I don't know, I'll have to find out.
See, it's happening, eh?
So returned to sender, I have seen the report also. Darius Ba.
Fine.
Tubro.
Addressee expired, hence return.
Oh.
Addressee expired.
Have to substitute them.
Substitute?
Yes.
The review application, strike them off.
I will have to find out who is the substitute actually and then.
Notices to respondent number 2 and 5. 2 and 5, correct?
2 and 5.
Have returned as it appears that the said addressees have since expired as per the noting by the postal authorities. So Mr. Bora is permitted to take instructions. So what about you? You'll file affidavit? No. No need.
Sequel instructions, your lordship.
Yes. Mr. Pasante was the appearance today on behalf of 1, 3 and 4. 1, 3 and 6. So what about the other 4?
That is 4. Balen Tubru. I'll find out about this. Yes. 2 weeks, maybe?
Less up to 2 weeks. Yeah.
Item number 4.
My pleasure, your lordship. I'm praying for 1 week's time, your lordship, in this matter.
Who is the conducting counsel for number 3?
By Pallavi, Your Lordship.
Who?
Yutika Pallavi. By Pallavi.
Who's the
Yutika
wife
Pallavi.
She's from Shillong? No.
She's from Delhi, Your Lordship.
Response number 3 is whom?
Returning candidate, Your Lordship.
Return candidate, not returning candidate.
Return candidate.
Written application for adjournment due to the ill health of the conducting counsel number 3. You have no objection?
No, Your Lordship.
Application is allowed just after 3 weeks. Yes. 3 weeks or 2 weeks? 3 weeks.
Item number 5.
Lord, I pray for 2 weeks time, Lord, in this case for the respondent.
I have no objection.
What's the matter about?
Lord, petitioner, they have challenged the
Regarding
they have,
resignment
they
of
wanted
a
to,
contract.
They want to set aside and quash that money suit and the execution case, my Lord.
What do you want time for?
Lord, I just need some more time for preparing this case, my Lord. I have to go through.
You just enter the appearance, no?
No, my Lord, on the last.
Mr. Ensincon submits that he is not ready with the matter today. Condition after 2 weeks. Yes. Same not objected to by WNS. It is up to same not objected to by counsel to the petitioner.
Item number 6.
You are appearing?
Appearing entrance for the sole respondent.
Is it CRP?
CRP, Lordship.
Yes.
Matter may come after 3 weeks, Lordship, so that in the meantime I will complete my instruction and prepare for the
Mr. S.A. Upadhyay has entered appearance today on behalf of the sole respondent. Such service is complete. This is the matter after 3 weeks for further orders.
7.
Yes, Mr. Sen also told me that he needs some time. Mr. Sen told me needs some time, I think.
Have you received a copy? Then we'll listen for hearing.
Yes, actually.
Yes, at the period to complete this matter for hearing on so and so.
2 weeks, my friend.
For 2 weeks or so. Yes.
8.
May I please, Your Lordship?
Yes.
Lordship, as per your law's order, we have to pay ex gratia payment. That is as per the 14th of August, that's not been done yet, and letter has been sent to the brother of the Yaina thing for to provide the no objection certificate from family members and the thing. As may I provide?
You said that on 25th of July, will be immediately?
Lordship, as per Lordship's last order, what has been recorded, the specific submission has been recorded that on receipt of documents as specified in the earlier letter, compensation of so-and-so will be released immediately. Those documents have been submitted long back. Now,
what's the problem?
Now, 2 days back, they come up with further requirements. Now, they want FIR copy, NOC, etc. This is a never-ending process. It's a clear attempt at evading the issue, my lord.
So it appears that in spite of the order dated 25/7/2023, wherein undertaking was given by the Council for the Respondent Corporation, that on receipt of the documents as specified in letter dated, the earlier letter,
Letter dated 24th July 2023.
24th July 2023, the amount of ex gratia compensation would be released immediately. Today, Mr. H. Karwan Lang has produced a letter asking for additional documents. This, in the opinion of the court, is not acceptable. Accordingly, he said the amount directed to be released within 1 week from today. Feeling which what, Mr. Karwan Lang? Describe your punishment. Within 1 week from today is
highly placed.
Yes, after 1 week.
Lordship, if these documents can be provided So in
You already said as per documents on the 25th July letter 2023, correct?
Lordship, this is requirement of the FIR and the NOC of the family members, Lordship. Which
Is it indicated in the earlier letter?
No, madam.
No, Lordship.
Is it a fact that he lost his life, he lost all his limbs to electrocution?
Lordship, that's
then what more do you need? Fellow lost both his arms and his legs, correct?
Lordship.
Then it's just a torso, and even you have to go through all the red tape. What will happen?
Objection.
Number 9.
Let me inflict heavy costs on the persons in charge.
Lordship.
Please, Your Lordship, I humbly pray I needed 2 weeks' time to file the affidavit, Your Lordship.
What's the matter about? How many times you've taken?
This is my 5th time, Your Lordship.
5th time?
Since the month of April.
What's the matter about?
This is for settlement of fisheries, Your Lordship.
You ready? You have the file with you?
Yes, Your Lordship, we will file affidavit on the next set, Your Lordship.
Last chance may be given, Your Lordship.
By the time I feel all the fish have gone also. Now you see, what a kind of case is this? Now, who is point number 5 is whom? They appeared.
No, Your Lordship. They have not
I've been served.
Yes, Your Lordship. For both the respondents, both the private respondents.
No, the same, but then I think someone appeared on behalf of this person. Now 5 months from July again.
15 months, Your
This
Lordship.
is absurd. No wonder you can't file affidavit. Who was this? Who was Kunal Koch? Represented? Yeah.
No, Your Lordship. He also has not made the entered appearance.
You made him party.
Yes, Your Lordship.
This is very strange. In spite of repeated chances, an affidavit has not been filed on behalf of the respondent stock. The instant case has a checkered history involving the tender of Borobilla, Borobilla, fishery. Stop. It appears by the imperial order that the respondent number 5 has been allowed to run the fishery for the remaining period of 15 months from 8/7/2023. Stop. Next paragraph. Though notice has stated been served on the said respondent number 5, that's also number 4. You served. Are they served? You sure?
Pardon, Your Lordship.
They've been served number 5.
Yes, Your Lordship.
You file
Because
affidavit of service.
No, Your Lordship. As per the AD card has returned to the registry, Your Lordship.
That's so. Problem. Since 25th of April 2023, none has entered appearance on their behalf. Similarly, with the respondent number 4, accordingly, the matter shall proceed ex parte against his 2 respondents. The matter shall appear 10 days hence, exact date, 10 years hence, and even no affidavit will be filed by the respondent that date, the matter shall be disposed of.
Lordship.
We'll dispose of, we'll give her the fishery.
Your Lordship.
Then I'll file it on as ex.
Without tender, you've given it again? Yes.
I'll leave, Lordship.
Nice. How much further time?
2 weeks. Lordship.
1 to 5 and 6 here for MTTC. Further 2 weeks. 2 weeks time.
2 weeks.
Granted response file affidavit just thereafter and so on.
Highly obliged.
11.
Lordship, I pray for further 2 weeks time, Lordship, for the affidavit.
3 weeks time was given last time, page 5/7. What's the matter about?
It's regarding termination, Your Lordship. Termination.
Of whom?
The petitioner is
Teacher.
the assistant teacher, Your Lordship.
You've been appearing for whom?
My lord, I am entering appearance on behalf of respondent number 3. That's the managing committee, my lord.
Number?
Number 3, my lord. Managing committee, my lord. Yeah, my lord.
Respondent 4 is
The respondent number 4, my lord, is an inquiry officer. What my lord will recollect this. This is the 3rd round of litigations. A teacher who has deserted since 2015, my lord. 2015. Of course, there was some procedure on our laps. The court has directed us to conduct inquiry. We have appointed an inquiry officer, and the inquiry officer has given all his finding. We have given them a notice. Now they have suppressed that notice, but they have annexed only the inquiry report. How did they get if we have not served them a copy?
Why have they made this inquiry officer the party?
Yes, exactly, my lord. There is no allegation of biasness against the inquiry officer.
Lordship, actually, I don't have a brief right now.
That's not an excuse to make.
And
who's appearing inquiry officer? You are appearing? Yes. For number 4?
Number 4.
Unnecessary. Where's Mrs. Sinkan?
Lordship, he was here. I think he's on Slack.
Gone for tea?
No, Lordship, he's here only.
Let them strike out the inquiry officer. There's no
You take a call on that. Yes,
Not the instruction.
Mr. P.U. Ben is appearing on behalf for number 3 today. How much time for affidavit?
2 weeks time I'll file.
2 weeks time. You will take a thing, you can fight for striking off this. That's all the parties represented. This matter after 2 weeks before the orders. You take a call. I'm not recorded in order.
Lordship.
12.
Village Gamburas, my lord, was supposed to get instruction. Last occasion also he was absent.
Yes, Your Lordship, I apologize for the last occasion. But Lordship, I humbly pray under 2 weeks we are yet to receive the instruction.
What's the matter about?
Regarding the election of the Gaumburas, my lord, village admin.
What happened?
That previous Gaumburas is already expired, my lord.
You're a son of the Gaubura?
No, my lord. We are the villagers. Because there is so many candidates, so we convene the meeting. But in the meeting, so many candidates are there.
Who's looking after the village now?
Nobody. No one, my lord.
Who are you? You one of the villagers?
Yes, my lord. And submitting the representation also. My name is there.
You are interested, you want to be Gaubura?
No, my lord.
You don't want to be?
No.
Then why you just...
No,
why
we are selecting the appropriate, suitable candidate, my lord.
We dispose of?
No, Your Lordship.
No affidavit?
No, Lordship, we will file the affidavit.
No meaning?
We are yet to receive the instruction, Your Lordship. We have sent the letter.
Then no need for instructions. You will dispose it off, then whatever is the outcome, you settle it. Since you are not bothered to come to the court and come instructions to settle the matter in court, let there be breaking of heads there only, that you'll be responsible for that.
Lordship, we have...
Well, that is what will happen of GJC. No efforts forthcoming. We'll send it back there, let them break each other's heads, and we will write an order also. Any outcome of, this dispute, will be squarely on the shoulders of the GJDC who have not, addressed the issue when it's been brought for the court or brought before them by way of representation. There'll be no way out.
I apologize, Lordship, but we will positively on the next day. We'll get the instruction.
You tell your senior, then let jungle law prevail.
No, otherwise nowadays...
You agreeable to that?
No, Gaumburas have to issue the certificate for birth certificate.
No, let them have, you have the election. We'll direct them that send some officer to have election. Breaking of heads, they're fine. Let it be, at least one Gaubura, the strongest will be successful. By might or by right, whatever.
No, right will not be possible.
Otherwise, we can't leave matters like this. The village has no Gaubura and they're not doing anything.
Lordship will get the instruction positively on the next day.
Just delay the matter.
The matter appears to be urgent as much as the grievance of the petitioners that the only grievance for the petitioners that the respondent authorities, that is the executive member, land and revenue Garo Hills Council, has not yet conducted elections to elect the new Gaubura. Which village is this?
Mola Kandi village, my lord.
Mola Kandi?
Yes, my lord.
Village. Stop. Today, time is again sought for instructions. It is to be noted that this court, by order dated 11/8/2023, had sought instructions and had sought this order by order dated 25/7/2023 had sought for instructions. Stop. And the matter was fixed on 11/8/2023. On 11/8/2023, none appeared in behalf of the respondents. Today, MSS Marpana, on behalf of the respondents, has appeared and seeks time to obtain instructions. The conduct of the counsel for the respondents as well as the respondents does not inspire a lot of faith in the system, in their system of administration. Accordingly, according to absence of instructions for the next day, the matter shall be decided on the materials available on record. This is a matter on after 2 weeks. If you don't come by then, these matters, I think they'll have Garu, especially if you don't file affidavits, we'll have no choice.
Much
and record an order that consequences, whatever, they're all truly liable upon this council. They should do some work.
13?
Yes.
Please, Lordship, they are supposed to get instruction, Your Lordship. This case, Your Lordship. My name is recommended.
May I please, Your Lordship, I need some more time. I am yet to receive any instruction. And moreover, Your Lordship, I was asked to search for a judgment. Your Lordship has pronounced one's judgment, but it does not. The judgment doesn't cover this
I have
case.
that judgment. That is regarding the teachers who are placed in the religious institution.
Private
This is not nothing. This is
When
the
you ask for judgment?
That on the motion day.
It was verbally mentioned.
Your
my lord.
Lordship, it is
For
not
the 2 weeks time granted to the responsible
3 weeks,
affidavit.
Your Lordship.
3 weeks, yes.
Yes. The item number 14 is the same, Lordship. 15
This
is the
item
same.
number?
13 and 14. This is the 13, Lordship.
13 and
And then the 15 is the connected matter.
15 order 15.
Lordship. Marvelous, Lordship.
Much 14.
Your Lordship, in this matter, the state is to file an affidavit, Your Lordship.
I pray for further time, 2 weeks time. File, yeah.
Mr. Ichkan pays for and allowed for the 3 weeks time to file affidavit. Yes, thereafter.
16.
You are appearing for 5 and 6. Number? Number. There's no number for former respondent. District Council's former respondent. Where's the court title?
Number 6. Should be 6.
Should be 6.
Same of.
What about
Same of
5?
Ibrahim.
5 is the main respondent. What do you want number?
Minriang, from Minriang village.
You should notice.
Yes, Lordship.
Yeah. Interpret them now.
Performer 6, right? Your name? MS P. Tarek appear on behalf of spot number 6. But performance are important. What's the matter about?
It is important, Lordship, to some extent, because he was directed by the other respondents, KHDC, to give certain orders, Lordship. So, KHDC being the higher authority, he was compelled to pass certain orders. So that's how we have made him the performer respondent.
No, no, it's a performer. 5 is a performer.
No, not 5. 5 is the main
yes.
respondent. 6 is the performer respondent.
Yes, so if also indicates that the service respondent for 5 is not yet complete. Stop. You obtain status on number 5.
Okay, Lordship.
Why you await service?
By postal service.
You've already taken steps, correct?
Right.
But
yes.
the AD card is not returned. So we'll wait after for some time. Yes, so and so is ended up in behalf of former respondent number 6 today. None appears, or the office note indicates that notice respondent number 5 is yet to be received. Stop. Yes, Mr. Kanta. Anything to say?
No, I'll rely on the records.
At least after 2 weeks for service report number 5. Yes.
Hearing supplementary list item number 4.
Please, Your Lordship.
Yes.
Lordship, subject to correction, yesterday respondents had finished their arguments. So I am to respond on whatever has been argued. There are four basic points, four major points which have been argued. So with Lordship's permission, I'll dive right into the points. The first point that was raised, the first argument that was raised by the respondents relates to the provisions of the contract 58.2 and 71.
Yes.
Contract in contrasted with these judgments which I had submitted yesterday, those 4 or 5 judgments from various high courts. So the attempt has been made on the part of the respondents to distinguish those judgments from our present proceedings.
The only point that he's put forward is that those clauses that are present in the other case we cited, it covers all disputes. While your case, there's a distinction in the sense that he's trying to make out a case that arbitration is separate, and other disputes which will come up due to whatever other reasons in the transaction, whatever in the execution of the contract will come to 58.2, which is like courts of Shillong, civil courts will have jurisdiction.
Absolutely,
that's all. Yes.
Absolutely. I'm grateful for my lord summing up the argument raised. Now, this argument which has been advanced, my lord, on the face of it, it appears to be a creative argument, an argument that has some merit on the face of it, but a little further scrutiny will reveal that there is no foundation to this argument. Now, firstly, my lord, the fact that these judgments which I submitted yesterday, those 5 judgments, all those clauses appears to cover all disputes. And the argument is that our clause does not appear to cover all disputes. So therefore, there is the obvious difference which is being sought to be highlighted. Now, the question is that really so? Does our clause really not cover all disputes? I submit it does. A little closer examination, a little slower examination of the clause will reveal that it covers all disputes. Now, before I trouble Lordship to look at the clause again, Lordship would firstly have to kindly appreciate what exactly is the transaction between the parties. In other words, what exactly is this contract all about? Now, firstly, madam, yes, ma'am. Now, firstly, I don't think there is any dispute or difference of opinion between the parties that this is a commercial contract. It is a commercial contract to set up certain infrastructure, to set up what they call a make-up water system connected to 9 gas turbines. Now, in such commercial contracts, the obligations of the parties, the respective obligations, are very simple and very clear-cut. Contractor has to perform certain work. I am supposed to pay him for that certain work which has been performed. Now, disputes which can arise between us will be connected to these obligations. There might be a dispute as to the quality or the quantity of the work that has been performed. There might be a dispute as to the quantum of payment which has been handed out by me. Besides these disputes, besides these disputes, there cannot be any other disputes between us. In other words, my lord, besides all these disputes which are
no, your sub is that whatever dispute only relate to the transaction regard to the contractual obligations.
Absolutely,
that's all.
Absolutely.
Yeah,
So
any dispute, commercial matter,
any dispute between us has to be connected to the contract. It has to arise from the contract. It has to relate to the contract. It has to pertain to the contract.
Yes.
Now, just to substantiate that, if I can trouble Lordship to kindly look at volume 3. Just to drive home this point, my lord. Volume 3.
If I may pray, my lord, before proceeding further with the matter, I have instructions, Lordship, if this matter can be taken at the bottom of the list. Because my lord, my senior, my lord, he is in lax in the other court, my lord, he is in the middle of hearing. That is the instructions, my lord.
He's just replying. You take down notes.
My lord, if any new points
you take down notes, Mr. Panti. How many years you practice?
Lordship.
How many years you practice?
10 years, Lordship.
More than 10 years.
More than 10 years.
Then you can jolly well argue yourself. You take down notes. What is there? So the question will be shutting you down. Yes.
That's what happened. That's
Lordship, volume 3. Lordship, may kindly look at page 001431.
1431.
001431.
Yes.
This, my lord, at 001431 is the statement of claims filed by respondent before the tribunal. The contents of the statement of claim are important for me to substantiate that the dispute, the nature of the dispute between us. If Lordship looks at the first claim, claim number 1, that is at page 001436, about 3-4 pages later, claim number 1.
Page 1436.
1436, claim number 1, extra expenses incurred due to increase in the size of pump house, according to the designs, etc., etc. I will not go through all that. Extra expenses incurred, contractual dispute arising from contract. Claim number 2, extra expense incurred in providing extra opening in intake well, extra work, contractual dispute arising, relating to, pertaining to contract. Similarly, my lord, claim number 3, cost of conducting the ultrasonic tests arising from contract, connected to contract. It goes on. There are 14 claims. To cut the matter short, bottom line is, my lord, all claims, in other words, the dispute between us today,
yes,
is connected to the contract.
Okay. Yes.
Now,
next point.
Now, just to complete this point, my lord. Now, if all claims evidently on the face of it are connected to the contract,
they'll be covered under 58.2.
Are they not covered under 58.2? They would be 58.2. If I'm allowed to read for possibly the last time, 58.2 at page 43 of the compilation. The court situated at the place where the headquarters of the corporation is situated, namely Shillong, will have jurisdiction to entertain civil suits pertaining to the contract. Now, pertaining, my lord, is a very interesting word that has been used.
Yes.
Will have jurisdiction to entertain civil suits pertaining to the contract. Now, if I'm allowed to focus for 2 minutes on this word pertaining, what exactly does it mean? Pertaining, my lord, luckily for us, has been explained by the Supreme Court. If I can just submit 2 judgments on this. First judgment, my lord, is from 1988. Paragraph 50 of this judgment, I have just given the extract at page 2 of this compilation.
Page?
The second page, page 2,
50.
paragraph 50, my lord.
Yes.
The expression in relation to, so also pertaining to, they are used interchangeably, my lord. In relation to, pertaining to, is a very broad expression which presupposes another subject matter. These are words of comprehensiveness which might have both a direct significance as well as an indirect significance depending on the context. See State Waqf Board versus so and so. Lordship, this other judgment which Supreme Court has referred to is the second judgment I'm relying on, that is at page 3. This is the Madras High Court judgment from 1968 of fairly old vintage, but was recently approved by the Supreme Court last year in this highlighted judgment, my lord. Now, page 6 may kindly be looked at.
1966 judgment.
1968, my lord. AIR 1968. The last citation.
Decided on 66.
That's a SCC online citation.
So decided on 66, March 30th, 1966.
Yes, my lord. Yes.
Yes.
However, approved by the Supreme Court last year, my lord.
Yeah. Yes.
Unfortunately, there are no para numbers, but if Lordship kindly turns to page 6 of this compilation.
Yes.
Page 6, third paragraph, my lord. We have no doubt.
Yes.
I'll read, my lord. We have no doubt whatever that the learned judge, Kailasam judge, was correct in his view that even the second suit has to be interpreted as within the scope of the words employed in section 57(1), namely, in every suit or proceeding relating to title to Waqf property. There is ample judicial authority for the view that such words as relating to or in relation to are words of comprehensiveness which might both have a direct significance as well as an indirect significance depending on the context. They are not words of restrictive content and ought not to be so construed. So in relation to, pertaining to, they are not words of restrictive content, context. They cannot be construed in that manner. And that is the attempt on the part of the respondent to restrict 58.2 to certain disputes.
Yes.
So, as far as the first argument that 58.2 will not cover all disputes, Lordship, that is not correct, for the simple reason that all disputes, the nature of disputes which arise or which are likely to arise between the parties in this case will under any circumstances be covered because those would be contractual disputes. About 3 or 4 occasions, senior counsel appearing for respondents said that other disputes will not be covered, without bothering to explain what sort of other disputes could they possibly be. Casual example was given that the wall is to be painted white, it's painted blue, that is not covered. I submit even that is an arbitrable dispute, because the contractor will have to rectify his mistake. He will raise a fresh BOQ which will be paid or not paid. That becomes an arbitrable dispute. So any and all disputes are covered. So to sum up my response on this argument, those 5 judgments spoke of all disputes. My clause here, 58.2, may not have used the word all disputes, but it comes to the same thing. Every dispute between parties in this case will be covered under 58.2, so no distinction can be drawn between arbitrable and non-arbitrable disputes. First response. The second point that was raised, and it was a point I was hoping that would not be raised because it doesn't hold much merit, but a lot of time was spent on this, on section 31(4) of the Arbitration Act. Now, what was argued in 31(4) under this point was, this was on the issue of whether or not determination of venue or seat had been conducted. Reference was made to 31(4). If I can read 31(4) again. An arbitral award shall be made in writing and shall be, etc., etc. I'll just skip to number 4. The arbitral award shall state its date and the place of arbitration as determined in accordance with section 20, and the award shall be deemed to have been made at that place. So the argument advanced was that, look at the award. Award has a place, has mentioned a place, New Delhi. Therefore, under 31(4), it is deemed that the determination was conducted. This is not correct. If I'm allowed to point out, 31(4), my lord, on the last round of hearing also I had spent some time on this. 31(4) has a certain chronology, my lord, has a certain flow. Arbitral award shall state its date and the place of arbitration as determined. So first there has to be a determination of the place. Then once the determination has happened, in other words, if Lordship recalls the authority on this, express an expression of opinion, a positive expression of opinion. No positive expression of opinion as far as place or venue is
positive determination.
A positive determination of the issue. No such positive determination is present in the records. So first there has to be a determination. There is no determination. First there has to be a determination. If there is a determination, then it will be deemed that the award was made at that place. So first determination, then deeming provision comes in. Then you can deem that the place which is mentioned in the award is the place that has been determined. So what the respondents are requesting this Honorable Court is to look at the award. The fact that New Delhi has been written out there shows that it has been determined at some point in the past. Lordship, the flow is very clear. First determine, then you can deem. They want this Honorable Court to do the opposite, to reverse the flow. Because there is a place, you deem it that determination has happened. That flow cannot be reversed in that manner. There is a way to understand this provision 31(4). That understanding cannot be reversed to serve the purposes of the respondent, my lord. So to look at the award and to say that because New Delhi has been written in the award, it can be deemed that New Delhi has been determined to be the place of arbitration. That causes violence.
Another thing is that he's raised a point that whether an award made in Delhi can be set aside by court in Shillong on the basis of territorial jurisdiction.
If the law allows for it, my lord. If the law allows for it, why not? Because if I can give an example, it often happens, my lord, that arbitration proceedings.
Because it relates that to para 59 of BGS Soma.
Yes.
That proposition is overruled by the courts of Bombay and whatever.
I'll come to that.
And so the thing is that only on that point where he said that whether the entire process, the venue was there, translates to a seat.
Yes,
that is. I mean, he's not said those words, but he said translate to a seat of arbitration, and naturally, when the arbitration took place, the courts there will have jurisdiction. Otherwise, can it be? Anyway, yes. Just on that point, yes.
I appreciate the query that has come from my lord. But if I'm allowed to give an example, my lord, proceedings are held at a certain place. It often happens in a lot of cases, in some of the cases which I have done also, that arbitrators decide to retire or to seclude themselves in some other place for 3, 4, 5 days to discuss the entire issue and to write their award and to publish that award. In one arbitration conducted in Bombay, arbitrators decided to seclude themselves in a resort in Goa. Parties happily paid for it. They stayed in Goa, they published the award in Goa, place was Goa. Does that make Goa the seat of the arbitration or the venue of the arbitration?
In this case, he's saying that because there's a positive determination from the beginning with regard to jurisdiction and regard to venue,
yes,
fine, venue is maybe in Timbuktu,
yes,
but then the courts of
yes, madam.
That so will have jurisdiction. That is on that point only.
Yes, madam.
So he said in this case where then nothing is clear.
Yes, madam.
Because from 10 whatever he read that other page.
Yes,
regarding the venue be the same place.
Yes.
So he's trying to develop arguments in that manner.
Yes, madam.
So anyway,
I understand.
So don't make it long. I mean, just what do you have to say on that as well?
Yes, madam. About the argument that has been raised that if the venue or the proceedings were conducted in Delhi, would Shillong Court have the jurisdiction only because of the application of territoriality?
Yes.
Would it have the jurisdiction or the authority or the right to set aside or to adjudicate a Section 34? My quick response to that is that if the law allows for it, it does.
Okay.
It is not like Shillong is a stranger to this entire transaction. Cause of action has arisen in Shillong, and I submit
that point, cause of action, he says that fine, para 59 has been overruled. We don't look at that.
Para 59 has not been overruled. I'll just
we don't look at that also. That's not very relevant.
Yes.
In the context of this court. The only thing is that on the materials and facts that are before us, like what can be determined. That's the only thing.
Very well.
And the only thing that's troubling is that 58.2 and the 71. That's the only thing.
Yes,
ma'am. That's the only thing. Now, you're correct. He's not shown any arbitral dispute that can be strictly, go arbitration, or whether you can discern between what will come to 50.2, what will come to 71.
Yes.
That it's up to their wisdom, whatever they argue.
Yes, ma'am.
But that's the only thing. So, we understand if law allows, why not? Yes. What if it's
absolutely.
There?
If the code, if the law allows me to do that, and most importantly, if I and the counterparty have agreed at some point, right at the beginning, that we will bring our disputes to this particular court, we are required to bring the disputes to that particular court under 58.2, my lord. So to answer the question, if everything happened in Delhi, will Shillong Court have the authority or the right or the jurisdiction? If law allows, if the contract allows, why not, my lord? That is the second argument. Just two more arguments have been placed, and I'll quickly address them. one argument is connected to that order which was passed by the tribunal
regarding the
venue.
The oral request for
Oral request.
change of venue.
Yes, madam. Yes, madam.
Okay.
That is volume 4, madam. Volume 4, page 2028.
Yes.
2028.
Quite familiar with it now.
I'll just read this two paragraph order again. Arguments on the matter on the application filed by respondent under so-and-so has been heard in part. For further arguments in this application, the case will be taken up on so-and-so at the same venue. Mr. Sanjeev Rohtagi orally submits orally that the next hearing be fixed at Shillong. This suggestion can be considered only after a proper application is filed for change of the venue.
Yes.
4 times my senior friend read this portion. He 4 times consciously, unconsciously omitted the venue. The venue relates to the venue mentioned in the first paragraph. So, and yesterday also I had submitted, the fixation of venue through this order was only limited for the purposes of the next date. So, when a request was made to change the venue, it referred to the venue which was fixed for the next date.
Okay.
Number 1. Number 2, much was made of the fact that Mr. Rohtagi asked for a shift of the venue. He was asked to give a proper application, and for the next 10-15 years, he did not give an application. Hardly matters, my lord. Hardly matters for the reason that, as I submitted, the fixation of venue through this order was only for the next date. Next date came, hearing was conducted, sitting was conducted, another subsequent date was fixed. This matter of shifting the venue for the next date, it died a natural death. So the fact that 10-15 years he did not file an application, he was not required to file an application.
Inconsequential.
Inconsequential if he was maybe
satisfied.
No, Lordship, if on that day when he was asked to file an application, maybe he was not equipped to do so with pen, paper, etc. So he did not file an application on that day. Next date came, sitting was conducted. This issue of shifting venue obviously died a natural death. So nothing much can be read into the fact that he never filed an application. He was not required to file an application.
Okay.
So the venue which is spoken of, to sum up, my lord, the venue which is being spoken of in this 2028 order is the venue only for the next date. And when shifting of the venue was requested, it was only shifting of the venue fixed for the next date, not a venue that was fixed at some point in the past as a permanent venue. Now, repeatedly submission was done that this order indicates that at some point in the past, a venue has been fixed. Some cricket analogy was advanced that if I tell my friend, come and play cricket without mentioning where, it is understood that at some point we have decided we will play our cricket matches at a particular place. So, without mentioning or without specifying the location of the venue, since it says only venue, it means at some point in the past, venue was fixed, venue was decided. If that be the case, where is the order fixing the venue? Where is the effective expression of opinion?
Okay.
Positive expression of opinion. No such order exists because at no point in time was there a positive expression of opinion. Venue was fixed on a need basis, on a daily basis, fixing the venue for the next date only. This is the third argument that was advanced.
Last argument now.
The third argument. Now the fourth argument. Very small argument. I will not take more than 2 minutes on this. This relates to BGS Soma. Lordship has already said that it's not very relevant, but for completeness, if Lordship allows me to address that also. BGS Soma 2020 Volume 4.
Yes.
Firstly, my lord, para 98 was referred to.
2020 volume 4.
2020 volume 4.
Yes.
Firstly, my lord, para 98 was referred to. Now, before that, my lord, just to reiterate and refresh lordship's memory, the importance of BGS Soma is contained in para 61. Para 61 says, if lordship has it, para 61.
Express designation.
Yeah, it will thus be seen that whenever there is an express designation, there's no concept of implied designation of a venue and no designation of any alternative place as a seat, combined with a supranational body of rules governing the arbitration and no other significant contrary indica, the conclusion is that the stated venue is actually the juridical seat of the arbitral proceedings. So there has to be, in the absence of a contrary indica, venue can become the seat if there is no other indication. Para 98 was read. This para 98 has to be read in that context, my lord. Para 98, if I am allowed to read. However, the fact that in all the three appeals before us, the proceedings were finally held at New Delhi and the awards were signed in New Delhi and not at Faridabad would lead to the conclusion that both parties have chosen New Delhi as the seat of arbitration under section so-and-so of the Arbitration Act. This being the case, both parties have therefore chosen that the courts at New Delhi alone would have exclusive jurisdiction over the arbitral proceedings. Therefore, the fact that a part of the cause of action may have arisen at Faridabad would not be relevant once the seat has been chosen, which would then amount to an exclusive jurisdiction clause so far as courts of the seat are concerned. Upon reading para 98 in isolation, it appears that if the venue has been fixed or designated or impliedly designated and everything happens in that particular venue, then your jurisdiction, then your cause of action court has no value. Then Shillong will have no value because everything has happened in Delhi, because you have chosen, in other words, you have chosen Delhi as the seat. Venue becomes the seat. But if there is a contrary indication, then venue will not become the seat. In this...
No, what I don't understand. What he's trying to say is that if there's express designation of venue,
yes,
then it follows...
Yes.
The cause of action will have no relevance.
Yes, my lord. If there is an express designation of venue,
then the whole of proceedings, their appeals are filed there, so like that venue will translate into, although venue and seat are two different things.
Yes.
But in this case, it translates to venue.
So if there is an express, yes, my lord, lordship is very right. If there is an express designation of venue,
then it is a different ball game altogether.
No, lordship, the venue will be promoted to the status of a seat if there is no other contrary indication.
Exactly.
If there is no, now in this case, in these three appeals, there was no contrary indication. There was no 58.2 or some similar clause. Number one. Number two, my lord, again, para 59. If I'm allowed to spend 1 minute on this para 59 again.
Yes.
Now the law contained in para 59, my lord, speaks for itself. Not to drive home a point that is so self-evident, but if I'm allowed to read the last, from the last of page 288, the fourth last line, also where it is found on the facts, also where it is found on the facts of a particular case that either no seat is designated by agreement, our case, or the so-called seat is only a convenient venue, again our case, there may be several courts where a part of the cause of action arises that may have jurisdiction. Again, an application under Section 9 of the Arbitration Act so-and-so may be preferred before a court in which part of the cause of action arises in a case where parties have not agreed on the seat of arbitration, and before such seat may have been determined on the facts of a particular case by the arbitral tribunal under Section so-and-so of the Act. In both these situations, the earliest application having been made to a court in which a part of the cause of action arises would then be the exclusive court under Section 42, which would then have control over the arbitral proceedings. Last line was stressed upon. For all these reasons, the law stated by the Bombay and Delhi High Courts in this regard is incorrect and is overruled. With my limited ability, I have not understood the significance of this. Yes, the law has been stated or clarified by the Supreme Court. Bombay Delhi High Court in some other judgments had taken an opposite view. Their views have been overruled. But the law has been stated. So the law has not been overruled if that is the submission that was advanced. So para 59 is very clear. Para 59 says that if there is a venue and no seat, then multiple courts will have jurisdiction, including the court possessing cause of action. That means the Shillong court.
Okay.
And para 50, that is sorry. Now para 59, my lord, is a reproduction of the principle contained in Balco. A passing submission was made yesterday that Balco does not speak of concurrent jurisdiction. I beg to differ, my lord. Balco speaks of the opposite. Balco in fact speaks of concurrent jurisdiction at para 96. Now para 96, Lordship has read it, I'm sure, a dozen times at least, but para 96 is very clear. I will not spend too much time and read para 96 again. Para 96, my lord, speaks of concurrent jurisdiction. Two courts having jurisdiction, your seat court or your cause of action court. If there is no seat court, since seat has not been determined or decided upon, then the only other available court is the jurisdiction, the cause of action court, which is the Shillong court, my lord. In summation, what is before my lord is a situation which has been addressed by multiple high courts. The same fact situation has been addressed by multiple high courts through proper and comprehensive analysis of the law. Multiple high courts have come to a certain conclusion, a conclusion which is in my favor. Respondents have attempted to dislodge those conclusions through their attempts, but I'm confident I have managed to meet those attempts. I would request that these judgments which I had submitted yesterday would be enough of persuasive value for this honorable court to reach the same conclusion that multiple high courts in multiple cases have also reached, my lord. I had prepared a synopsis of arguments which I had submitted earlier, but because of these 5 additional judgments and today's 2 judgments,
it's all right, I think, yes.
If Lordship allows me to slightly modify, I just need to insert 3 paragraphs, my lord.
Okay.
Now, just to avoid confusion, if I'm allowed to take back the earlier synopsis, and I'll submit my modified synopsis by tomorrow, my lord. That's all.
I don't think, Mr. Paul, any substantive, it's only answering 15.2.
It's only answering one point on law.
Well, on law, yes, okay.
I don't think my learned friend will disagree. Well, it's the point of contradiction between BGS Soma and Balco is para 96.
1 second.
Because my friend has submitted before your lordships that...
You see the point of contradiction?
Only point of contradiction between BGS Soma and Balco is para 96. As a matter of fact, in BGS Soma, my lords, the lordships have held that para 96 is not in consonance with the entire judgment.
Okay.
I'll just take that relevant portion in BGS Soma, my lords. The lordships had heard us at length on this issue at
I don't want to repeat this.
I will not take your lordship. I'll just mark
the earlier round of hearing.
Well, I'll just point out
that,
the relevant paragraph.
We concluded fast. Yes.
1, 2, 3, 4.
Para 96.
Para 96 of Balco, my lords, was held in BGS Soma to be not in consonance with the text of the entire body of the judgment.
Yes.
And my lords, that's why it was, my lords, sought to be declared as a bad law, but just give me the relevant page of the SSC.
Page 308.
Page 8. There's no page 8. Just, your lordship will just bear with me for a second, my lords. BGS Soma is again so huge.
Page 308.
Well, it is here. I've got it. Well, it's the relevant paragraph is paragraph 49 of Balco, of BGS Soma.
49.
Well, it's...
Yes. Opposite conclusion.
Now let's take the consequence of the opposite conclusion in light of the facts given as example as follows. New Delhi is specifically designated to be the seat of arbitration and the arbitration clause between the parties. Part of the cause of action, however, arises in several places, including where the contract is particularly to be performed, let us say in a remote part of Uttarakhand. If concurrent jurisdiction were to be the order of the day, despite the seat having been located and specifically chosen by the parties, party autonomy would suffer, which BALCO specifically states cannot be the case. Thus, if an application is made to the district court in a remote corner of Uttarakhand Hills, which would then become the court for the purposes of Section 42 of the Arbitration Act 1996, where even Section 34 applications have to be made, the result would be contrary to the stated intention of the parties, as even though the parties had contemplated that a neutral place be chosen as the seat, so that the courts of that place alone would have jurisdiction, yet any one of the 5 other courts in which part of a cause of action arises, including courts at the remotest corners of the country, would also be clothed with jurisdiction. This obviously cannot be the case. It is therefore the conflicting portion of the judgment of BALCO in para 96 is kept aside for a moment. The very fact that the parties have chosen a place where the seat would necessarily carry with it the decision of both the parties that the courts at the seat would have exclusively have jurisdiction over the entire arbitral process. So para 96, my lords, what the lordships held in BJ Soma was not in conformity with the body of the entire BALCO judgment.
Yes.
And as I pointed out earlier also, my lords, BJ Soma was subsequently followed by the Honorable Supreme Court in numerous cases, including Brahmani pellets, Brahmani river pellets, and then subsequently including decisions in last year, which have been passed.
So Brahmani pellets is 22-5, right?
Pellets.
2020, volume 5. 2020, volume 5. I mean, yes. Which paragraph?
I'll just. So many judge, it's here, Manoj.
18.
Yes.
Para 18.
18 and 18.
Para 18. I think para 18.
Lord.
Para 18.
Read with para 4.
What I'm trying to say is, Malaj, BJ Soma, because one of the arguments raised was also that BALCO is a 5-judge judgment and BJ Soma is a 3-judge judgment. But the fact of the matter remains, Malaj, BJ Soma has been consistently followed by the Honorable Supreme Court.
So Nariman to realize the mistake actually. Anyway, yes, that's it.
96, Malaj, otherwise also when we read BALCO, Malaj, 96 is an aberration from the entire judgment. That's what I personally feel. I don't know, my learned friend would probably feel otherwise.
In respect to BJ Soma, my lord, a very interesting word has been used by my friend. BJ Soma has held 96 not to be in consonance. A 3-judge bench cannot hold a 5-judge bench's judgment to not be in consonance or to even have the authority to clarify that judgment. So BALCO still holds the field. BALCO, para 96.
When you file your points by
tomorrow.
By tomorrow.
By tomorrow?
By tomorrow. So that there is no further confusion, because then what happens with passage of time, even we forget what was.
No, I'll put it Monday. Monday, I'll list it. I'll list the matter so you file it positively. I won't accept it after that. Couldn't accept it after that. This is matter for filing bullet points on Monday.
Published.
I haven't concluded, yes. For our hearing concluded, fixed for filing bullet points on Monday.
Main is item 18.
May it please your lordship, learned DSGI is paying for some accommodation in this matter, your lordship. As per the limited instructions I've received, I've been informed that a new director has recently been appointed.
With regard to?
This is an NIT matter, your lordship.
NIT?
This is with regard to the trainee teacher scheme, my lord.
Oh yes, 3-4 cases are there, my lord.
Well, 2 cases are listed today. My lord,
My lord, my friend has been given ample opportunity, my lord. The director was appointed on 7/8/2023, my lord. Now, in both the cases which are listed today, my lord, the vacancies are there. Vacancies are there.
No, but
that
vacant post has been kept for you.
Yes, my lord. It
Yes.
has been kept for me. But, my lord, what with the lapse of time, my lord, I am suffering on account of academic points, my lord. My career progression is being
next week.
Suffered, my lord.
Your Lordship.
Where are the two matters? Listen together. Are you listed today?
Both matters are listed.
No, the other matters? The only two.
My lord, only two matters are there, according to my knowledge, my lord.
I don't need to. That fellow went to Mizoram, came back, and no, it's not the case, huh?
No, my lord. This is not that case.
That is.
My lord, this is a case where there is a scheme. The scheme provides for certain requirements. My lord, those requirements have been met with. This is a pan-India scheme, my lord, where all the NITs have applied the scheme in letter and in spirit by giving appointments to those who have fulfilled the mandate of the scheme, save and except the NIT of Meghalaya. My lord has heard this matter also, my lord. The scheme is very clear, my lord. It's not a part-heard matter, my lord. It has.
Your Lordship is not.
It has not. It has not been heard.
Where is Dr. Mbazike? Not in court.
Your Lordship, he's on legs, Your Lordship, before courtroom number 4, Your Lordship.
So, my lord, last time, my lord, let it come up next week, my lord. My lord, if I recall correctly, my lord, my last time Dr. Mozika had sought time for seeking instructions, and his submission was that the director has not been appointed.
That?
The director has been appointed and he will seek instructions and
7th, 8th has been appointed on 7th of August.
On the 7th of August.
Oh, that's only last week. Okay, this matter after 1 week.
1 week.
Yes. For further hearing.
My lord, let it not come on 22nd, my lord, on any day other than 22nd.
Why?
My lord, I have some obligations on 22nd. Will it come up on 23rd?
23rd is
that is September. This is 23rd is a Wednesday.
This was matter on 23rd September.
23rd September.
On the Priya M. Srumthau, who seeks some accommodation due to unavailability of the senior arguing counsel, this matter 23rd.
Both matters there is mistake. My lord, there is an interim.
That will continue, sir.
Until further orders, I think, is there?
Yes, sir.
Until further orders.
Yes, sir. We don't need to say.
She has made sure of that last time, I think. Yes.
Oblige.
21.
Your Honor, I am for respondent number 1 and 2. Your Honor, due to some urgent matter, Your Honor, my senior Miss P. Bhattacharya, she went out of town, Your Honor.
He left the?
No, she went out of town.
So what to do?
I can leave the matter after 2 weeks, Your Honor.
Just the arguing counsel for the Provident Fund for respondent number
1 and 2.
1 and 2. That will due to some personal emergency. This is a matter of 2 weeks. Yes.
Oblige.
And so item number 22 also.
22.
Last one, isn't it? Machu.
I'm for the 22 also.
1 and 2.
I'm for respondent number 2 and 5.
2 and
5.
2 and 5.
Deeply obliged.
23.
Please Lordship, actually.
Where's the state council?
Mr. Karmi is appearing actually.
Call him. What's the matter about?
This is regarding termination, my lord. They have alleged me that I'm irregular. There is allegation against me that I'm irregular, and then questioning the conduct of the petitioner, saying that I was not obedient. That is an allegation. They said that. What is this one? Poor conduct. They said that I make a fabulous complaint against the respondent. Poor past conduct, including irregularities. That is the. He's on court number 4, it seems. Can be taken up some other day, otherwise. Otherwise, my lord, this one actually, this is only the reason because I filed the complaint against the respondent saying that there was harassment. Impugn order is at page 28, Annex 7, my lord. There they have mentioned it was directed by the mission director.
Where's the contract? Where's the contract of employment?
That contract employment, first I was appointed, that appointment was there. I have annexed it, that annexation number 1, where is just they have given me this and this is not a contract, but that contract was not there. But this is the appointment order, initial appointment order on 26 February 2015. Lordship.
This is 15.
Yes, from 2015 I have been working till 2000, December 2000, till I was terminated.
You file a suit.
But allegation against me was that actually they saying that I was poor. That is only ground saying that a poor past conduct, including irregularities. But there is no specific
discipline violation conduct.
Nothing was specific. How many days, how many months I was absent, that is not there. And then also absence. In what way?
It's not absence. It's regarding that you did some hanky-panky out there, making complaints and all.
However, yes, Lordship, their complaint, they have recommended there are 5 persons who make a complaint. But the inquiry officer have recommended 5 persons to be removed from the service. It is there, but only the petitioner is removed, Your Lordship. Is page number 26, Lordship. There are not only the petitioner who make a complaint against him.
Yes.
They said that recommendation for suspended the remover of the incumbent. That's Srimati Gloria Esmara, Srimati Tracy Mary G. Moman, I am the petitioner, and Srimati Memories Esmara. But out of these 2, I am the only, they have removed the service, but these 2 persons there, in fact 1 person, Gloria, has been already regularized in service. And Gloria, even till today, he is making still complaint is there again. He has filed, after even filing of the petition, she has filed another complaint, but no action has been taken. She has filed another complaint against the same state respondent. This is the complaint.
How long Mr. Mukherjee take?
That one otherwise the same yardstick should be followed, because there are 5
can't ask for negative equality.
Yes, but same otherwise it's a discrimination. If there are 5 complainants who make a complaint against the respondent, only I was terminated. Other 2 are still allowed to be, other 4 are still allowed to be remain in service, and one of the complainant who is still on 24/6/2023 also, yes, see that Gloria, same complainant, he has filed a complaint against the same respondent, Dr. Lovingware only, the respondent number 4. and she's regularized. Why only the petitioner is terminated? And also, Lordship, if they say that allegation is against me that I am irregular, the misconduct, then they should take action against the petitioner prior to filing the complaint, because they said there's a numerous explanation code was issued to me and I have replied. It happened in the year of 2002 prior to the filing of the complaint. This is only just because I have found out not only the petitioner and others, they have filed some complaint of public workplace harassment, and then inquiry report also there, neither inquiry report, nothing was supplied to me. It is only, we come to know only from the affidavit filed by the respondent. Even the private respondent number 4 will, as for the inquiry, they were found guilty of, because as for the provision of this lordship, there is a punishment. Punishment is described in section 9 of the harassment of sexual harassment of women at workplace. That 9th section this described, and exactly the inquiry officer have found out that he reflected in the order that it is at page para to page 27, then the para 11, they have clearly mentioned the para 11 page 29 of my rejoinder. He was found guilty of harassing. As per the section 9 of the sexual harassment of women at workplace, the punishment is described in that. And exactly the inquiry officer, after going to the complaint made by the petitioner and others, he has reflected that complainant allegation of scolding, reprimanding, using improper word and unsuitable word, asking them to resign, the threat, termination, insulting and humiliating, causing embarrassment to this complainant need to be taken into consideration, and written warning can be given to DHMO to refrain from continuing with this attitude and behavior. This is the inquiry report by the internal. Actually, the internal is going to be considered as an internal committee. It was conducted by the magistrate. The sub-observation has been made against the respondent.
No matter when before the court, they found nothing. Like they found nothing in the allegations. See the affidavit.
Lordship, that case is still pending in the court. No. It has not been disposed of.
Why you say that? See, it's all this that they found nothing. That the allegations are all, the allegations you made are all false.
That order passed by the district session judge is still under challenge.
What does it mean? Passed is under challenge. That means that your case is proved. When your case has been disproved, you file appeal.
Yes, we have filed it against this one for not taking the action.
See what's the orders there of the CJM.
The CJM make this observation without issuing any notice to the petitioner. I was not given an opportunity to file a show cause on that case. And that similar
no
case...
No professor case reflect in IO report. Don't see any infirmity in inquiry report of both the MHO. Also, I would opinion the complainant developed her own subjective ideas against the superiors when superior made admiration in addition to performance of duties, but the same nature connected to making sexually colored remarks or any other type of remark. Sexual nature. Admonition she received presence of other staff members. I mean, a bit harsh, but at times, her own explanation suggests the same was not made. See, you were scolded maybe in front of other staff members because you don't like to work. From 2018, you don't go to work, you don't attend meetings, you do whatever you feel like, and then when you call for explanation, you say sexual harassment. Now that's why your complaint was dismissed, right?
No, the complaint.
Your complaint was dismissed by the judicial magistrate. That's in 6/2/2023. So against that you file. So you say that there's some substance in your complaint because I filed an appeal against his order.
No, Your Lordship.
Is there any?
Inquiry report speak even.
Forget inquiry report. One inquiry report. You're a contractual employee. If you behave in such a manner, what can they do? See how many explanations that has been given to you. How many?
We have
how many?
reply.
Just tell the court how many explanation letters been given to you. How many?
See,
how many? How many? You are a lawyer. You know how many explanation letters have been given from 2018 onwards. How many?
Only
how many?
Annexure 8, 9,
how many?
10, 1,
how many?
3, 4, around 4, Your Lordship. I have enclosed whatever.
What dates?
4 and 5.
From when?
Your Lordship. From Annexure 8 to Annexure 13.
Yes, from
all
when?
my reply, Your Lordship.
From when? From which year to which year?
From 2000, August 2022. From August 2022.
No. From when's the first explanation call?
First explanation call asked.
When?
Actually, it is Annexure 8, Lordship. It is on
when
on 1st August on 3rd August 2022.
First explanation call when? When is the first explanation call? See? You kindly see? When was it filed? When was the first one? Explanation call. You see the affidavit, annexure 1 of the affidavit of respondent number affidavit economic order 11/4/2023. First explanation called in 5th July 2018, more than 5 years ago. Found to be absent always. Then next explanation, see another on 22, another in 22 again, another in. See how many explanation letters can they give you? How many? And you reply every time. And if you're scolded, you say sexual harassment. So how many? Yes.
21st October.
You went and ill-treated one doctor also. Poor fellow who's serving as a Dr. Lovingwell Sangma. Why you ill-treated him? Luckily, has he filed a complaint against you?
No.
Should file a criminal case against you for harassment.
See, only thing is that in the inquiry report, there are 5 complaints, not only.
See,
the
with reference, I have honored to inform as per order so and so. I regarding ill-treatment, doctor, you said that he has ill-treated you. Nothing. In fact, you've ill-treated him. Findings are given page 25 of the affidavit. Then all. Then.
But Lordship.
What?
One thing is to be appreciated. If the petitioner is doing the misconduct and the irregularities and misbehaving, what prevent the private respondent from removing me from the service? What at the time when, but they are waiting only till when I find out their mistake, their misbehavior.
No, what? They've removed you. Have given you enough chance. From 2018, given enough chance. Given explanation, you replied. They've kept you in service. Now they've had enough. Suppose you have one employee with you. You're trying to help them. They keep on misbehaving. They do this, you do that. First you tell them, why doing this? Stop doing it. Say, okay, Mr. P.T. Sama, I will not do anymore. Again they do again. Next year. Then you tell them again. Again they do again. Again you give them warning. Last you have inquiry also that, then they start saying that you're sexually harassing them. Then that also nothing is there. Just because you scolded them. You won't get fed up.
Lordship, one thing should be appreciated. There are 5 complainants.
The
inquiry officer have recommended.
No. You get fed up or not? We're not talking other 5%. Don't look at other 5%. Maybe they have said with folded hands, we are sorry, we'll not do anymore.
No,
only one who made complaint sexual harassment.
One is still complaining. I have the copy even after filing of the.
They also made complaint sexual harassment on being scolded.
Lordship.
Who made complaint sexual harassment among the 5?
All of them actually they have signed.
They made complaint sexual harassment.
Complaint is there in the Lordship. 5 of them have signed.
No. Have they made complaint sexual harassment? All of them.
Yes, Lordship. It is there in the annexure 3, Lordship. All of these 3 filed. Gloria, Tracy, Zimmerman.
Annexure 3 of writ petition.
Yes, Lordship.
Okay.
They have signed all of them. This is together. All the page 21. Annexure 3. And you see
wait, don't shout.
Lordship.
What kind of allegations you can make?
If there's a force agreement, then all the other complainant also should be taken, action should be taken against them also. And one person, Gloria, after even filing the repetition also, he has again filed a complaint against the same Dr. Lubingwer Sangma. And nothing, no action has been taken against her and no inquiry even till today. I have the copy also.
Where Mr. Kharmi? You ready with the matter? We'll finish it off.
There should be equity, Lordship.
What
Whatever
equity?
law action,
what equity?
Why facility should be done to the other complainant?
Your behavior should be such that
they were only concentrating, only targeting the petitioner.
Because you must be
five of them.
You must be a leader then.
No, Your Lordship, they don't speak. And
how come criminal case was only against you? You filed a criminal case also, FIR.
FIR was filed.
Then who filed FIR?
The petitioner filed.
Did the others file FIR?
He did not file. But it was after the termination.
Did you file FIR or not? Did you
file it? We filed it, but it is after the termination.
Alone you file FIR making the allegations, and the criminal court, they went into the matter. They said that after examining, you saw that only for scolding you said sexual harassment.
But the inquiry also have make some observation against the respondent also, Lordship. It is there in the report.
Doesn't matter.
And
You are
moreover,
concerned your case only. What happens to A, B, C, and D?
No.
Anyway,
Against the private respondent. It is not me, but the
matter stands adjourned to after hearing at some time, after hearing at some length, what's he, senior government advocate or what is he? What is designation? As the additional senior advocate was not available, said it to be occupied another court. Let the matter be listed after 2 weeks. Yes.
What's the Lordship?
Yes.